To lose. Thank you for starting the recording. Thanks to everyone coming today. It is Wednesday, July 26th, 2023. And Alexandra, I think I managed to close my, here, I'll reopen it. I managed to close my PowerPoint, but I found it. All right. You think 3 years of doing Zoom? I would be a pro at it by now. Okay. So we're going to be going over the ABCs of planning ahead for someone with special needs or disabilities. I'm Michelle Wolf, Executive Director at JLA Special Needs Trust and Services. We are a community-based profit. We provide pooled special needs trust and consultations and free education. And just to reiterate, we are not a law firm. Most people are going to need to see a trust and estate attorney to draw up their estate plan. Okay, all right. So we're going to cover why parents and grandparents should plan ahead, some elements of estate planning, the key players and their roles, then very, very briefly touch upon federal and state government benefits. I cover this in greater depth in our usual open house. Then some special needs basics. Who will be your trustee for your special needs trust? And then get into what we have and introduction to CalAble. Okay, why do you need a plan? So if you don't make plans, the government has plans for you. So God forbid parents die without having created a will or a living trust. What's going to happen is there's a protocol, an order that will be followed by the government. So typically, money from a parent's estate is going to be divided equally among the living children. So if one of those children has special needs and is already getting SSI and Medi-Cal, you can't set up what's called a third-party special needs trust after the fact, after the parents pass. So that adult with special needs would have to create a different kind of special needs trust called a first party. And the problem with the first party special needs trust is after that beneficiary passes away, the state of California comes calling and asks to be paid back, which means that there's not going to be any money typically left to pass on to other family members. So a really important takeaway is you need to plan ahead, and if you're going to set up a special needs trust, you want to set up a third-party special needs trust before the parents or the parents pass away. So I know this is a really unpleasant topic, having to think about, I mean, let's face it, death and taxes. And a lot of us have the very human tendency to push it off as long as we can. But it is important, and unfortunately, things don't always turn out as you plan. So let's talk about one of three really important roles in estate planning. The first one is, who are you going to name to be your executor of your estate? Another term for executor is personal representative. So the executor is the person that's going to kind of step in after someone dies to pay off bills, to settle debts, to deal with real estate issues of real estate that the person owns, that the decedent owned, and also to distribute money to the named heirs. The named heirs could be people, could be organizations, or like nonprofits. And the named heir can also be a trust, could also be a special needs trust. So it's important to know that most bank accounts are going to be frozen as soon as the person dies. No one is going to be able to get money out of that bank account unless the account was called POD, payable upon death, or there is a cosigner who's still living, and the cosigner has to be able to have full privileges with that bank account. The executor is going to have to shepherd the whole process from when the person dies to distributing inheritance. Now, what's really important to know is that the executor's job ends after all the assets have been distributed. And so the executor does not go on necessarily to become a trustee or to become the conservator. So what responsibilities does an executor have? So you can see here, they're named. Typically, a family member is named to be the executor. Someone, hopefully, it helps if they have some legal, accounting, or they're good with a bookkeeping background, because they do have to create an inventory of all the assets. So that would be things like bank accounts, if they own any stock, if they own any real estate, decide if there's any kind of probate necessary to go through the courts. In California, you really want to avoid probate. And the way most people do that is by creating a living trust while they're alive. And also, the executor has to pay off any outstanding taxes and file a tax return. The executor has to notify government agencies and pay off outstanding debts. So every estate, regardless if there's a special needs trust or not, needs a named executor. And the executor is typically going to work closely with a trust and estate attorney to make sure they're doing everything correctly. So that executor comes in, someone dies, deals with all the financial matters and taxes, and then their job is finished. Now, if there is a living trust the family has created, that living trust may have a named trustee. So, for example, take a typical situation. There's a husband and a wife. They've created a living trust. The husband sadly passes away. Then the wife becomes the successor trustee or just trustee of that living trust. So every trustee has to go by what's written in the trust document. So that trust document that has been created by a trust and estate attorney is super important. You can't change it after someone dies. There is a way to change it, but you have to go and petition the probate court. And so it's very rarely granted by the court, because basically a trust or a will is the intent of the settlor. The person who created that trust or that will is saying in paper, I want to give, my real estate to this person. I want to give my jewelry to that person. I want my life insurance policy to go to the special needs trust of my son. And all of that should be in writing, very important, before that person passes away. So a trustee is a much longer job than the executor job. The executor job is typically, if all goes well, 6 months to a year. But the trustee, that trustee job could last much longer. Sometimes people will name a bank that they, have used to be the ultimate successor trustee. But banks will not always accept that responsibility if there's not enough money. There is a safety net in terms of our government. Every county has a public guardian's office. So if there is a trust to administer and there's no trustee, the public guardian can step in. but typically they're not going to do that if there's money in the trust. Okay, so we've covered executor and trustee. The other important role for parents who have adult children with special needs and disabilities is the role of conservator. Some of you might already have been named the conservator in a limited DD conservatorship. In California, the limited DD conservatorship is used for regional center clients, pretty much exclusively. And then there's another kind of conservatorship called a general conservatorship. Those are typically used for an older relative who is no longer competent. So the best example of that is grandma develops Alzheimer's, and over time, she's not able to take care of her own financial and healthcare affairs, and she needs someone to really help her out. So the role of the conservator is much more encompassing and much more comprehensive than the role of the trustee. The trustee has what's called a fiduciary role over the money that's in the trust. That is strictly speaking the only role of a trustee. A conservator decides many more things: where the person can live, in some cases, if they can get married, have access to private health records, have access to educational records. So the conservator is supposed to step into the shoes of the conservatee, and the conservator is supposed to always keep in mind what are the preferences and desires of the conservatee. So, for example, if the conservatee was somebody who's been smoking tobacco for a long time, and even though the conservator thinks it's a bad idea, they should still try to respect that is something that the conservatee always enjoy doing. You could say the same thing for, let's say, going to a rock concert, or going to Vegas, or other circumstances. And then there's another role called conservator of the estate, and that means managing the person with disabilities' assets. And assets could also include real estate, stocks, bonds, money in a bank account, and money in a trust. I'm going to pause there for a second. Alexandra, are there any burning questions so far?
Actually, no questions yet.
Okay. All right. So those are all the different roles.
Oh,
now,
Lisa raised her hand.
Okay, Lisa, unmute and ask your question.
Hi, sorry, I was so busy typing notes that I didn't get a chance to type in the chat. Sorry about that. 2 questions. So, first, must I change in my documents the names, the titles of the co-trustees to conservators? I'm going to have like 4 different trusts, and one is an incentive trust, one is a special needs, one is an elder, and one is an addiction trust, sadly.
Understood. So the thing about the conservator, that can only be granted through a probate court. But what you can do in your estate document is indicate who you would like to see be successor conservators.
Okay.
So let's say, Lisa, you petition, maybe using an attorney to help you, you petition in the probate court in your county to become the conservator of your adult child. And then you can indicate in your estate plan who you would like to name, yes, to become the conservator after you, to become the successor conservator. But it's not going to happen automatically. That person would have to also petition, the court.
Well, is it okay then to just name co-trustees? I have 3 people, and they're the only ones I want to have handle.
I understand. Well, you should definitely talk to I don't want to get too much into detail with your particular case, but the problem with there's a problem with co-trustees is what happens if they don't agree. So, but you'll have to think whether you want them all serving together or you want them kind of, this one first if that one's not able to, that one second, and then the third person third.
I see. Okay. And then the next question. I'm in a situation, I have no assets. So is there any way to establish or to fund a living trust without real estate, for example?
Well, what's often used in special needs trust is life insurance policies.
That's all I have.
Yeah, so I'll stop the share for a sec. So what is often used is life insurance policies, 401ks, pensions. Those are all assets that are often available to more middle class folks.
Oh shit.
Okay.
They're available to whom?
I'm sorry,
sorry,
what was that?
I didn't hear the last part. They're available to whom?
Well, they have to be available to you first, right?
Mm-hmm.
Yeah, I mean, we're not going to be able to invent assets.
There's copies. I
So
got
any
it.
money, please mute yourself. If everyone could please mute. So the plan doesn't mean if there's no assets to fund the plan, then not much is going to be able to get accomplished with the plan.
Okay, but I can take my pension and establish that as a living trust?
No, well, it's a little more complicated than that. You definitely, Lisa, will need to see a trust and estate attorney. Okay?
All right,
All
thank you.
Sure. I'm going to go back in and go ahead. Oops, not letting me share my screen. All right. Here we go. All right. So we'll kind of come back to those roles after a while, but I'm going to move slightly from all those different roles and people you're going to need to name in your living trust or your will and talk about more specifically about special needs trust. So traditionally, the main reason to have a special needs trust is to help someone with a disability keep their government benefits. And the reason why that is so is because many government benefit programs have asset limits. Sometimes they call those resources, and they often have income limits. And generally speaking, there's two kinds of income by definition in these government benefit programs. There's earned income, that's money, from having a job or having your own business. So generally speaking, from employment. And then there's unearned income, and that could be things like investment income, or it could be child support, or it could be alimony. All of those things are considered unearned income. And government benefits are really important and helpful, but they're only designed to get people barely to the federal poverty level. So in 2023, 100% of federal poverty level is only, $1,215 a month, and it's $30,000 for a family of 4. These numbers change every calendar year based on inflation and the cost of living. Welcome to those of you who just joined us. If you have any questions, please type your questions in chat. I don't know. Oh, here we are. So on the left-hand side of the screen are what's known as need-based benefits. So that means the government is going to be asking about your income level. You have to be low income in order to qualify. So on the left-hand side, we see supplemental security income, SSI. So many adults with disabilities who aren't able to make a living end up receiving SSI. It's possible for children under the age of 18 to receive SSI, but their parents have to be very low income in order for the child to get SSI. And Medi-Cal is also need-based. Now, Medi-Cal is getting rid of the asset limit, but they still have monthly limits. And it's important for everyone here in California to understand that what we call Medi-Cal here in California, that's really part of the federal Medicaid system. But in California, everything's a little different. Our Medi-Cal program is operated out of Sacramento, and some of the rules in California are different than in many other states. So it's something to keep in mind, especially if you're thinking of moving to another state, to check out how the Medicaid is, because it varies quite widely in terms of benefits. Now, on the right-hand side are entitlement benefits. So it doesn't matter what your income level is. If you meet the criteria, you can still get the benefit. So SSDI, that stands for Social Security Disability Insurance. So if you've been working a certain number of quarters and you get sick or disabled, you're able to ask for and get something called SSDI. When people say they're going on disability, that's what they're getting. Also, Medicare, pretty much every U.S. citizen over the age of 65 is able to get Medicare. Also, some younger people with disabilities are able to get Medicare. So this is a chart that shows that government benefits can change over time. So from 0 to 18, the child is a minor. Parents have full legal responsibility for that child. As soon as the child turns 18, and it doesn't matter how severe the disability is, that child is considered an independent adult. So for some people with more severe disabilities who are going to need lifelong assistance, for some of them it might make sense to pursue conservatorship at age 18. For other adults with disabilities, there might make sense to pursue a power of attorney or some other shared decision making. But it's really important to understand that at the age of 18, parents have no legal right to see health records, education records, and the child can independently apply for SSI, even if they're living in the parent's house at the age of 18. So let's say when the child is 62, their parent retires, and then that child can receive a different benefit called the Childhood Disabled Benefit, and they get half of their parents' Social Security. So this only kicks in when one of the parents actually retires and starts getting Social Security retirement checks. And then, sadly, let's say the parent dies when that adult child is age 55, then that adult child with a disability can get 75% of the parent's Social Security. And then Medicare becomes eligible 2 years and 5 months after receiving this particular benefit. So that's how many adults with disabilities, after they start receiving this childhood disability benefit through their parents' earnings, they end up on Medicare even if they're below the age of 65. So I'm going to very briefly talk about SSI, Medi-Cal, and in-home supportive services, and then I'll take a little break, and then we'll get right back into the Special Needs Trust. So SSI, right now in California, the max for most people is $1,470. I'm sorry, $1,133. That's the maximum cash benefit. The most you can earn from working and still get SSI is $1,470. Those numbers change every calendar year. So the great thing about SSI is you get this automatic linkage to Medi-Cal. And it's the best kind of Medi-Cal because there's no share of cost. And it's the best kind of Medi-Cal to have. So you want to get SSI, even if it's only going to be a small amount of SSI. So some people think that their adult child with disabilities shouldn't work because then they'll lose their SSI. They don't lose their SSI. They do. There's a penalty of 50 cents on the dollar, minus $65. But anyone who works and is on SSI comes out ahead than if they were not working and just getting exclusively SSI. So this is some more information about that childhood disability benefit. It's kind of confusing. I don't want to spend too much time on it, but there's a lot of good information in this slide. So the most important takeaway here for parents is when you plan to start getting your Social Security retirement, there's a little box that says, do you have an adult disabled child? If you have an adult disabled child who was diagnosed before the age of 22 and is now over the age of 18, you need to check that little box. You will be asked to fill out some other forms and provide a physician's proof. But this is a really important benefit. Also, when you're sitting down to talk to financial planners, it's very important for that financial planner to know that this is a possible revenue source when parents retire. Here's some more information about what is SSDI. Again, that stands for Social Security Disability Insurance. I don't want to get too much into it, but a lot of our adults with disabilities end up with a combination of SSDI and SSI. They get SSI because they haven't been able to work very much, and then they get SSDI based on their parents' earnings through Social Security. Okay, what is Medi-Cal? So I think most of us know what Medi-Cal is. That's Medicaid on a national level. In California, that covers a huge range of medical costs, medical visits, also covers durable medical equipment. That could be a wheelchair, that could be an insulin pump. It covers hospital care, and most importantly for many of us, it covers in-home care. And also Medi-Cal is the only government program that covers long-term care, meaning in a skilled nursing facility. So Medicare only covers 100 days post-surgery or post-hospital visit long-term care. So it can be a real pain in the butt to get Medi-Cal and to keep your eligibility, but it's very helpful in the long run to keep that eligibility going. You can have both Medi-Cal and Medicare. That's called dual eligible. It's also called Medi-Medi. So it's a good thing to have both. Now, where it gets a little tricky is Medi-Cal is administered through the California Medi-Cal office in Sacramento. Medicare is administered in Washington, D.C. And sometimes there can be some disagreement and there can be different approaches because the programs are being administered in two different jurisdictions. You can also have private health insurance, like from an employer, and then Medi-Cal. Medi-Cal is always going to be secondary or in some cases tertiary. Medi-Cal has the lowest reimbursement rates of all forms of health insurance. So what is IHSS, in-home supportive services? So this is a Medi-Cal benefit. So you must have Medi-Cal first in order to qualify for in-home supportive services. It's a state of California program, and it pays caregivers an hourly fee. It varies in the state. In LA County, it's now $17.50 an hour. The County Department of Social Services is going to be the one deciding how many hours based on the individual needs of the beneficiary. They're going to come to the house and actually assess the beneficiary. Do they need help getting up from the bed? Do they need help going to the bathroom? Do they need help brushing their teeth? Do they need help making breakfast? Do they need help with their medications? And then you get so many hours based on the individual needs. A really good thing about IHSS is that family members can be paid care providers. You can also have someone who's not a family member. And people who get SSI and IHSS can also get CalFresh. That's also known as SNAP or food stamps. The income level has to be, that's monthly income, has to be 200% of federal poverty level or less. It's pretty easy to apply, and you get a EBT card in the mail. A lot of people don't get very much per month. Some people get as little as $40, $45 a month. The average for a household is $130. And those of you who have disabled adult children living at home, they can apply, but the adult child has to be over the age of 22. So it's a little extra wrinkle in there. So the big change with Medi-Cal is Medi-Cal used to say if you had more than $2,000 in the bank, you would be disqualified from Medi-Cal. That has changed. It changed July 1st, 2022. So this is the current asset limit. And in January 1st, 2024, Medi-Cal is eliminating altogether the asset limit. So that's good news for a lot of people. Okay, I think I'll pause here. Are there some questions?
Yeah. If you were a conservator, can you access your adult child's medical records?
You should be able to, as long that was one of the powers that was delegated to you by the court. So if you get a limited DD conservatorship, on the conservatorship papers, it will say you have the power to do 1 through 7 powers, and it'll say if you have the right to access confidential records. And then if you have that right, you will have to show a copy of your court order to like medical insurance, personnel.
Irene wanted to know if we will be getting the slides. I will email those out tomorrow. Yes, I have all your email addresses through Eventbrite, so you will get a copy of this. I know it's a lot to digest. Is it absolutely mandatory to get a conservatorship for an 18-year-old with muscular dystrophy whose parents handle all of their medical needs?
The problem is what happens if you go traveling and you have to meet with some medical personnel that's not familiar with your family history. And they'll take one in, let's say that, your adult child is now 30. They'll see that birth date and they'll say, I can't talk to the parents without permission of that adult child. So that's where having a limited DD conservatorship might come in handy. Or if the adult child is competent, you might not need a conservatorship. You might just be able to use a power of attorney. So, conservatorships are not mandatory. They're not for everybody. To the greatest extent possible, we want our adult children to have that agency and to participate fully in important decisions in their life. But so it's a family by family decision. But I know a lot of families will say things like, I've been going to the same doctors forever. What difference does it make that they now turn 19? Well, that doctor could retire. You could lose your health care plan because, your employer changes insurance companies. So just the fact that you've never had an issue with your current healthcare provider doesn't mean you might not run into an issue down the road.
Can an adult who receives IHSS and works part-time get SSI benefits?
Yes. They'll have to qualify for SSI. And one of the main criteria for SSI is the question is, can this person engage in what the government calls sustainable gainful activity? In other words, can this person, yes, it's great that this person can work 10 hours a week or 20 hours a week, but can this person really work, enough hours to make a living? So that's the main criteria for getting SSI, aside from being low income. In other words, the fact that you have X disability does not give you automatic SSI. You still have to make the case that that adult with disability is not able to have SGA, sustainable gainful activity.
Did you cover this person was late qualifying for Medicare before age 65?
Yeah, so just real quick, the way someone under the age of 65 would qualify for Medicare, most of the time, would be based on the parent's earnings, the parent's Social Security earnings. And the parent would have to be receiving Social Security retirement benefits, and the parent would have had to proactively apply for that adult childhood disability benefit. Yeah.
If you want to go back in the presentation, we'll be sharing a recording and we'll be sharing the slides. Here's another question. What if the parent dies before they were able to work on a living trust?
Then the government just divides up the money the way it is typically done, which means money would be split evenly among all living heirs.
Upon our death, our will specifies that all our assets need to be put into a trust at JLA Special Needs Trust. When this happens, what's next? Who will oversee our son's assets? Who will oversee his care in terms of the regional center?
So if you formally named us, it's great. I hope you've actually, I'm not sure who that came from. I hope you've actually formally enrolled in our future funded trust, which I'm going to talk about in just a minute. I mean, hopefully you've given a copy of our future funded trust to your attorney, to your regional center service coordinator, or to a sibling. I mean, someone has to notify us. We're not going to find out, unfortunately, that a parent's passed away until someone notifies us. And then typically, I mean, what's happened in the past is typically we work with the family attorney. We'll work with the named executor of the estate, and we move those assets. Let's say the simplest thing is a life insurance policy. So the simplest thing is the life insurance policy is named to Thomas Cohen's Special Needs Trust at JLA. And then, we just get a call from Colonial Life Insurance saying, hey, we have a check that's made out for Thomas Cohen's Special Needs Trust. I just want to verify the address. And then we verify the details. We receive the check. The money is put into the trust account. And then we start dispersing funds. And we're going to work with the service coordinator. We're going to work with, if there's a family member that's been named as a beneficiary advocate, that's also known as the trust protector role. In other words, that's a family member. Typically, it's a sibling who can act like a liaison between the person with the disability and the trustee. And that beneficiary advocate would help us create a spending plan, help us figure out where bills need to be paid. So the regional center, they will not administer your private trust funds. That is considered a family issue. the regional center will continue to, provide whatever services they're already doing, or those services might need to be changed. So let's say the adult was living with the parents and the parents died, the regionals, and there's no place else for that person to easily go to, the regional center would, find like a group home placement for that person. Any other quick questions, or should I dive back in?
Can we provide a list of LA Area Special Needs Trust estate attorneys that we recommend?
Yes, we have a list. But yeah, I need to know the specific person and their email. Yeah.
Okay.
Any other?
No, I think we're good to continue.
Okay. Everybody staying perky, drinking? Okay. All right. So we talked about the estate basics. You need to figure out who's going to be your executor, who's going to be the trustee, maybe a conservator. And then let's say you decided that your adult child needs to keep all those government benefits. So then you want to make sure you have a special needs trust as part of your estate plan. It needs to be written into either your will or your living trust. It can't just be in your head. It needs to have the words written on a piece of paper. And typically it's a notarized document. So the special needs trusts are designed so that the person with a disability can keep all those government benefits that we just discussed, and then have access to money that's in the trust using a trustee. Now, there's a couple of important facts about a special needs trust. The money in the trust has to be used for the benefit of the beneficiary. Once the money is in the trust, you can't pull it out and use it for another sibling or use it to start a family business. It has to be used for the benefit of the beneficiary. And really important, it has to be irrevocable. So a living trust, as long as the settlers are alive, let's say mom and dad are alive, they can keep changing that living trust up to their last breath. But a special needs trust, once it's set up and there's money in the trust, it cannot be broken, because as soon as you break a special needs trust, those assets become available to the beneficiary, they become available resources, and then you would lose the government benefits. So a special needs trust is a really important thing for every parent of an adult over the age of 18 with a significant disability to consider and to discuss with a trust and estate attorney. Okay, so there's two different kinds of special needs trust. So the one you want to do is the planning ahead one, the third party. And that is assets that are coming from parents or grandparents. We've had some very generous aunts and uncles. It could even be a family friend. You want to do this ahead of time. And what's really good about it is there's no payback to Medicaid after the beneficiary passes away, after the person with a disability passes away. So what happens if you don't plan ahead? And we've had plenty of these families come to us. You don't plan ahead. Usually it's the mother passes away. Money ends up getting inherited equally among the adult children. The person with the disability is on SSI and Medi-Cal. And so then that person who's getting SSI and Medi-Cal has to set up a first party trust, which we offer. And the problem with the first party trust is once that beneficiary passes away, the state of California comes calling. And there's a lot of expenses that have been paid by the regional center that you're probably not aware of, by IHSS, by hospitalizations. And the state of California puts out its little hands and says, we want our money back. So what that means is the money is not going to flow to other family members, whereas with a third-party trust, if there's money left over, it's gonna go typically to like nieces or nephews or grandkids, or even to your favorite charitable cause. So that's a really important reason to plan ahead. Now, most wealthy, high net asset people use a professional trustee. So that means they're going they're going to use a bank or a lawyer or a commercial trust or a professional fiduciary to manage the special needs trust for their adult child after the parents have passed. A lot of middle class families want to use a family trustee because it costs less, right? Because you're using a family member. But the problem, there's a lot of problems with using a family trustee because it's complicated from what we were just talking about. Family trustees can find that being the trustee on a special needs trust is a lot of work. There's legal issues, there's tax issues, there's these benefits to keep up with. And then there's also that interpersonal relationship. You know, what happens if the sibling with special needs is texting their non-disabled sibling, 10 times a day? I want that new video game that dropped. How come you're not getting me that new video game? Put money on my card right now. Or could, and they could ask for a lot more expensive items, as we know. They could ask for trips or cars, all kinds of things. And maybe that's okay between two siblings, or maybe it's not. When you have a professional trustee, you're removing that dynamic and you're giving it to a professional. And as I was saying, we have a role for siblings that we call the beneficiary advocate. That's known sometimes as a trust protector role. So what our nonprofit provides is something called a pooled special needs trust, known as a D4C. They were created by Congress 30 years ago, and they have to be operated by nonprofits. And we create a master trust written by an expert, a lawyer who's an expert in the field. It's like an umbrella. And then people enroll under that umbrella by filling out a legal agreement known as a joinder agreement. Every beneficiary has a sub-account with their own money, and then the money is only pooled together for investment and cash management. So it's similar to a mutual fund. So why would a pooled special needs trust might be a good match for your family? It might not be. It's a lot cheaper to set up because we already have the master trust. You can have potentially higher rates of return because we're combining Jim's $50,000 with Betty's $300,000 with Michael's, $1 million. So you can see how we're able to leverage. I call it the power of community, using that pooled trust. Now, the thing about a pooled trust is everything coming into the pooled trust has to be liquid assets. So we've met with some people who own like a lot of rental properties, which is great. It's a great way to create income and revenue, but that's too complex for the pooled trust model. In that case, the family would need to go to an attorney and set up what's called a standalone special needs trust. We can still assist with some consulting and future planning and government benefits, but we would not be able to manage, we're not going to get in the business of managing rental properties. That's beyond the scope of what our nonprofit is able to do. So here at JLA, we offer a first-party special needs trust. That's what happens if people don't plan ahead. It's got that Medi-Cal payback, the third-party trust, and then what we're calling the future funded option. And so for many of you on the call today and many of the professionals, the families you work with, this is going to be the best option. What it's doing is it's setting up the structure of a special needs trust for the future. And then and it's only it's a total cost of $800 to set up, $600 enrollment fee, a $200 deposit into a money market account at Charles Schwab. And then basically we just wait. Unfortunately, usually it's a sad event. Typically it's the passing of, a grandparent or a parent, and then there's some life insurance money. There could be some pension money. There could be a sale of a home. And then the proceeds from that sale can go into that third party future funded trust. Once there's $20,000, we can start dispersing money. We create an individualized spending plan, working with the beneficiary, working with anyone else that's important in their life. So that could be a private case manager, that could be siblings who are beneficiary advocates, could be, sometimes we've been working with SLS providers through the regional center system. And then each person has their own individualized spending plan based on how much money is in the trust, based on how old they are, and based on how much government benefits they're getting, and based on their needs. So what can you buy with your special needs trust money? So it's pretty wide what you can spend the money on. In general, it's to improve wellness, optimize independence, and then enhancing quality of life. So here's some examples that our current clients are using their money for. Things that we all need, like a cell phone, clothing, electronic equipment, including computers, medical expenses that are not covered by any other health insurance, trips and vacations. If the person needs an aide with them to go on an airplane or to be in a hotel, we can pay for both the beneficiary and the aide. We can pay for additional in-home help beyond the IHSS hours. And the trust could also pay for a car, even if the beneficiary doesn't drive themselves, but the car would have to be primarily used to transport the beneficiary. And then also a residence. So the thing is, the trust can only buy one residence. So you can't have one residence they're living in and another residence that's like a rental property, because that's not permitted by SSI rules. We have a really strong partnership with a financial services company called TrueLink, based in San Francisco. TrueLink is a commercial for-profit, but they're very mission-driven, and they target people with disabilities and seniors with dementia. And they are our investment manager. All the money is actually held in Charles Schwab third-party accounts. And TrueLink also has pioneered this amazing restricted use Visa debit card. And so that's what we use with our clients. And we can open and shut entire categories. So for example, we almost always close things like pawn shops. And we close things like bars and liquor stores. And we close things like Western Union and wires. So we're able to give people optimal independence so they can go shopping or use their cell phone or buy the video game I mentioned at GameStop. On the other hand, they're not going to be able to, go to a pawn shop or go gambling in Vegas. I just want to spend a few minutes at the end talking about CalAble, which should be part of your financial planning and your estate planning. CalAble is a tax advantage spending program that's offered through the state of California. It's similar to 529 college savings accounts. You can only open it up online. You can't go into a bank and open it. And this is a great way to put aside money for someone with a disability without impacting their SSI. You can put up to $17,000 per year or whatever the IRS tax exemption is for that year. all the way up to $100,000 without impacting SSI. If people are working, they can put like another $20,000 a year into their CalAble account. So the thing about the CalAble account, the beneficiary has direct access to it. There's no trustee involved with it. So there's some positives with that, right? Easier access to your money. You don't have to ask or get pre-approval from a trustee. On the other hand, maybe that person is somewhat vulnerable, and let's say their new best friend says, oh, let's take all the money in your CalAble account and go to Hawaii for 6 months. Unless the person is conserved, no one else will be able to stop the beneficiary from doing that. So the CalAble basics is that the beneficiary had to have a disabling condition that started before the age of 26. That is going to go up eventually to age 46, but not for another couple of years. You can only have one ABLE account per Social Security number, and the beneficiary is always the account number, always the account owner. Everything in there is tax exempt as long as the money is being spent on appropriate qualified disability expenses. So just like with special needs trust, there's a lot you can use the money in the CalAble account for. You can use it certainly for post-secondary education, like a 529 account, but you can also use it for food, housing. There's certain advantages, in fact, for using the CalAble account to pay for rent instead of a special needs trust. You can use it for transportation. So there's a pretty wide range that you can use your CalAble account money for. So ABLE accounts and special needs trust work together. As I was saying, there's advantages to using the ABLE account to pay for your rent, that more direct control. What the experts are recommending is that you use your ABLE account more like a checking account, money in, money out, and then you use the special needs trust for the long-term needs and over the lifetime of a beneficiary. You can move money from a special needs trust to an ABLE account without any penalties. So that's kind of the current thinking. So as you start doing your planning, it's important to set up actually 3 different accounts for your adult child with special needs. A checking account. This could also be a RET payee account that accepts government benefits, could also accept work earnings if they're on the lower side. And then a CalAble account for when that checking account gets to that $2,000 limit imposed by SSI. Also, if someone's earning more money, CalAble's a great way to shelter that income. And then that third-party special needs trust, that's really that nest egg to provide for your loved one over the entire course of their life when the parents, unfortunately, and in most cases, will no longer still be with us. So I know that was a lot. We have a great website that Alexandra has created and updates constantly. So take a look at our website. This is my email. The best way to reach me is by email and to set up a phone call or a Zoom. We're also on Facebook, and there's our office phone number. I'm going to stop there and take some questions.
And we got a lot. We got a lot of email addresses interested in that listed as state attorneys. We talked about what role JLA Special Needs Trust plays and what we provide, so I don't think we need to recover that. Michelle, are you familiar with the state planning services provided at myadvocate.com?
No,
I'm not.
Yeah.
What or who determines disabled with regard to an adult child with an SMI? Do they need a specific diagnosis?
Yes. So it's the federal definition of disability, which is available online at the Social Security Administration. So typically, it's a disability that's gonna last. It's not a short-term disability. It's gonna last, at least a year. It's a disabling condition that results in the person not being able to work. That's really super important. You really have to make the case that the person with a disability is not able to work in any kind of self-employment or any kind of job and earn a living. And you will definitely need a diagnosis by a medical professional.
If JLA Trust doesn't handle rentals, do we sell the parents' home and put the proceeds into the pool trust?
In some cases, we have to because there's not enough cash. We're able to put, if there's a family home that the adult child with disability is getting full title to, that can go into the special needs trust. But in many cases, what ends up happening, there's a family home and there's the person with disability and there's two other siblings. So in that case, the family home would probably need to be sold and then the proceeds divided among the siblings.
How we talked about CalAble and how that fit in. Can you take a CalAble disbursement money and transfer it to the special needs trust?
Yes. And I saw somebody else asked about gifts. I think the easiest way is to just gift money into the ABLE account. Because the ABLE account right online has a way to do that, which is great. I just realized I didn't have my light on the whole time. Whoops. Whereas getting money into a special needs trust is a little more cumbersome. So the ABLE account, again, money in, money out, is a great way for family members to make like a donation, almost like a donation, but there's no tax deduction. It's really making a contribution into the person's savings account through the ABLE account. And I saw that Lisa's asking about if we have offices nationally. There's other pool trusts in every state, and there's a directory of pool trusts that I can probably put in chat. So if you have people in other states, there's definitely ways to get connected to the pool trust that exists. Next question.
We had a lot of technical questions about the recording and the slides. I can't put the slides and the list of attorneys into chat. It's just not uploaded to a cloud, so I can't just do it. I'm not prepared to do it, but like I said, I will be emailing the slides out tomorrow. We'll need someone else on staff to dig up the list of attorneys, but I can send that out to the email addresses I have. And I'll also, like when I send the general email out to everyone, I can ask and see if anybody else wants that.
So, sorry, I just want to emphasize, we're not a law firm.
Yeah.
And I know, Lisa, you were saying, everybody else is too costly. Even if you open the Future Funded Trust with us, which I hope you will still need to meet with a trust and estate attorney to work out the rest of your estate plan. And it's also every adult over the age of 18 should set up a power of attorney and a healthcare proxy. God forbid any of us could be hit by a bus tomorrow. You're going to need someone else to pay your bills or maybe make healthcare decisions to you. And even if you're married, yeah, your spouse will usually be the one, that's going to be able to step in. But it's still a really good idea to, in paper, specify who you want to be your power of attorney, who you want to be your healthcare proxy. It's really important that every family still go to a trust and estate attorney.
So
The storm,
we have a couple of this is a
all the
question.
goodies. I think I'm almost done, like 4 minutes.
Good, well, enjoy yourself.
We have a couple of families that are having trouble navigating the technology to maintain their CalAble account. Can they, or would they be able to use JLA's services rather than CalAble?
Sure, but we're not gonna disperse any money until there's $20,000. And we also, we have annual annual fees as well.
That was all the questions from chat. Oh, wait.
Okay.
Nope, anytime you say that, there are more.
Right, I can see Valerie's question.
Yeah.
If I have a completely dependent 18-year-old who will go to college close by and live at home, we're gonna take care of his needs 100%. We have a revocable living trust, that's great. And your son has a CalAble account, double great. Yes, you still need a special needs trust for the future. And the reason why you want to establish that special needs trust is, I hope you have some, or you'll get some life insurance. And so that life insurance policy, instead of going directly to your son as a beneficiary, needs to go to the special needs trust, for Tom Q Public. If you have a CalAble account, you do not need an additional 529, because a CalAble account can pay for anything, any post-secondary education that a typical 529 account would pay for.
Do you see what are our annual fees?
Yeah, so that's a great question. I'm gonna grab our fee schedule. So even though we're a nonprofit, we still have to pay for our own rent and to operate our own business costs. And unfortunately, the bank doesn't give me a break on my mortgage because I work in a nonprofit. I wish that were so. So anyway, nonprofits have expenses just like for-profit. So we are a nonprofit that charges fees. The fees are below market from what a professional trustee would charge. So here is the cost, and this is available on our website. Some places, and this drives me nuts, they won't tell you how much anything costs until you call up and talk to a salesperson. We don't operate that way.
Sonia, do you want to ask your question?
You know what, I'll put the URL in
Yes.
chat.
Yes. Hi. I have a question. For example, I have two sons. One is disabled and the other one's not. So if I leave my house under my other son, the not disabled one, can I write down something like this house cannot be sold or transferred or do anything with this house until my disabled son is passed away?
It's going to be hard to uphold that in court. We've unfortunately seen parents trying to do that, and it did not work out well.
So how can I make sure, my son has a place to live in my house? Is that another
Well,
way?
you would have to leave. Actually, you would have to do just the opposite. Leave title. You would have to create a special needs trust and then put title to the disabled son into the special needs trust.
Oh, wow. Okay.
Yeah.
I didn't think about that. I was completely the
Yeah,
opposite.
unfortunately, we've seen other parents say it is my intention, that, this house not be sold. The problem is, Southern California house prices, they're worth a lot, even the smallest house. And, quite often an adult child will want to cash in the house to use the cash for other purposes.
Okay. Thank you.
Yeah, so, yeah, you would need the special needs trust to own the house. That's the only way to guarantee that.
Thank you.
Okay. How we doing? Everybody, so I'm so proud. Everyone's like pretty much stayed to the end. Very impressive. All righty, I think we're gonna wrap it up. And thank you all for being such an attentive audience and asking good questions.
Can I ask one final question?
Sure.
How many times do we need to go through this PowerPoint presentation till we really and truly understand exactly what we need? It's pretty complicated.
It is complicated.
It's very
Yeah.
complicated and, you know, a one-shot go around, I mean, obviously gives us some inkling. But it's like, really, how, where else can we get this type of information? And
Well, we can set up we can set up a one-to-one consultation. We have some money for some free consultations of 30 minutes or less. If you need more time than that, we do charge $90 an hour.
mhm.
So you can email me and we can set up a consultation. I mean, some of this information, you know, is also available, you know, on various websites. Actually, that Special Needs Alliance website that I posted earlier here, that has a lot of good articles too. Let me post that as well. I know this stuff is very complicated, and you know we're asking people with disabilities and the people who love them and have so much already on their plate to try to, you know, navigate this very complex maze of services and benefits. Yeah, and like I said, the regional center doesn't, you know, they don't like to get involved with estate planning and with families' private money. You know, they'll get involved with government benefits and trying to maintain eligibility, but they won't get involved with, you know, the CalAble accounts and you know, how all the different pots of money can work together, which is unfortunate. But I think, you know, they have, you know, they kind of have their own lane that they're swimming in, and they don't feel like they can operate much out of that. So I hope that's helpful. And
Quick question. I'm so sorry to jump in. Thank you so very much for all of this information. It is overwhelming. Do you suggest we meet with a special needs trust attorney first and then decide whether we're going to go with your organization as the trustee, or no, wait, whatever that person is. Is that,
well, the thing is, some of the special, it depends who you talk to. So the problem is, a lot of the trust and estate attorneys out there don't even know about pool trust because we're relatively young. You know, we launched in 2016, so not everyone's going to know about us. So if you, you know, I definitely encourage you to go look at our website.
Right.
And, you know, if you are interested in using our services to, you know, take some information about us to the attorney. And,
right.
you know, we'll go through the pros and cons. Like I said, the pool trust model works best with simpler estates, you know, with money coming in from checking your savings, maybe life insurance, maybe a pension, you know, like a government employee pension or 401k. If you have more complex assets, if your family has certain complex, even investment portfolios, independent of a pension or independent of a 401k, it might make more sense to not use our services and to go with a standalone special needs trust.
Okay.
I noticed that you recorded this lecture. Is that available to us, the recorded?
It will be, but it will take a few days to process. I'll send it out with the email that I send out
So
tomorrow.
she's going to email this.
So the question about, is the presentation available in Spanish? We do have a Spanish version of our more generic open house. And we do periodically hold this in Spanish as well with our Spanish speaking staff.
Is
One
the recording of your lecture available?
Not today, because we just did it. So we won't even have this recording until we all get off, and then it will take a few days to process and upload. So immediately after this ends, no, it won't be. In a few days, it will be. I have your email addresses through Eventbrite, and I will send it out.
I'm gonna go ahead and stop the recording. And it's gonna go to the cloud.